Yes, Judge. I think that was one of the speakers. I don't know that Tina's joined yet.
Okay, so since the recording started, we'll get started, and hopefully people will continue to join. Can everybody hear me and see the screen? If you can't, please say something in the chat. I have it open in front of me. I just want to make sure we have clear access for everyone. I'm Therese Yanan. I'm with the Native American Disability Law Center. And for over the past 10 or 12 years, the Law Center has had a contract with the 11th District to represent Native American children who are in CYFD custody. We're going to talk today about the New Mexico Indian Family Protection Act, which is going into effect, or most of it's going into effect tomorrow, with a focus on working with tribes and Pueblos and the qualified expert witness portion. Our presenters today are Christy Chapman, who's also a GAL and youth attorney, as well as a member of the Zuni tribe, or the Zuni Pueblo, excuse me, Christy. And Austin Moore, who's a staff attorney with the Native American Disability Law Center, and Kip Braboff, who's general counsel for the Pueblo of Laguna. I'm going to turn it over to you, Christy.
Good afternoon, and thank you, Therese. Just want to introduce myself officially. I am Christy, and currently on our homelands of the Ashiwi here in Zuni, and wanted to just welcome you all for our third presentation today. We will. I'm starting correct, Therese. Sorry, I'm starting this presentation. We will be highlighting QEW, but before going on into the QEW, just want to highlight that the protections of ICWA originally and now with IFPA really included the Indian Child's Tribe as a party whose rights must be respected. And I just want to share with you this quote taken from Esther V, which was citing a Mississippi Band of Choctaw case. And it says that Congress enacted ICWA to protect the rights and interests of the parent, the tribe, and the child with an abuse and neglect proceeding, while an abuse and neglect proceeding is designed to protect the best interests of the child and the rights of the parents. ICWA does go further by protecting the unique relationship between a tribe and its children. Congress knew that removing Indian children from their family and tribe could negatively impact the tribe's long-term survival. So ICWA furthers tribal sovereignty by ensuring that tribes are able to raise their children with their own cultural and societal values. To that, I just want to reiterate that the purpose of ICWA and the protections of IFPA now really go to putting our kids at the center of the circle and protecting what we in Indigenous communities call our sacred trust. With that, I'm going to go to the next slide and I'll pass it on. Oops. I'll pass it on to Therese, sorry.
That's okay. So ICWA and IFPA define tribe in very similar fashion, especially with reference to the federal recognition. The Indian Family Protection Act does have this added provision at the bottom where Indian tribe also includes those tribal officials and staff who are responsible for child welfare and social service matters. One of the ways I think that this might come into play on a day-by-day practice in our cases is just making sure that the ICWA social workers and the representatives from the tribal social services are properly involved in all discussions. I also wanted to add that I was talking with Twyla, and she has told me that the Administrative Office of the Courts is working with some other entities to get another training specifically with ICWA social workers. We had hoped that one would be able to join us today, but they do have a very important perspective on how attorneys can work with tribes and pueblos, and so that hopefully will be a future training. And so I just wanted to make sure that you all knew about that.
Right, again, going back to where we are right now in New Mexico, again, just wanted to highlight that we are on our indigenous lands, originally made up of these the following native indigenous tribes, pueblos, community, tribes, pueblos, and nations. And just want to highlight that when we're talking about New Mexico, today we recognize that there are 23 tribes, nations, and pueblos, and what originally was the entire state of New Mexico inhabited by indigenous people, we now see where we are now. The next slide. In New Mexico, our sovereign nation and lands here are comprised of the Navajo Nation, the 23 pueblos of the the 19 pueblos, and then the two Mescalero tribes, Jicarilla and Mescalero. I'll pass the slide on. Excuse me, my voice is going out. Sorry. The next thing I want to share and have Austin present will be on notice to the tribes. Excuse me.
Thanks, Christy. So notice to the tribe. In a child custody proceeding, when the court knows or has reason to know that an Indian child is involved, the department shall notify the parent, guardian, or Indian custodian and the Indian child's tribe by certified mail with return receipt requested of the following, which is the pending proceedings, the right of the parent, guardian, custodian, and tribe to intervene, which I'll talk about a little bit here in a second, and then petition the court to transfer the proceeding to the tribal court, the right to do that. Third, the right of the Indian child's parent, guardian, or Indian custodian to court-appointed counsel. And then fourth, the right of the tribe to participate in the child custody proceeding. So why is notice important? The case above that Christy had highlighted, the Holyfield case, Mississippi Choctaw Band, stated that Indian tribes have an interest which is distinct from, but on a parity with the interest of parents. So notice really ensures that the tribe has the opportunity to assert its rights and to protect the best interests of the child. The burden for providing notice is on the party that seeks foster care or TPR. So often that is CYFD, but in certain cases it can be the court or even foster parents. And so notice goes to each tribe in which a child is a member or eligible for membership. There's also active effort requirements, as we discussed last week in the training. There are requirements that active efforts are given to comply with these notice requirements. And important is that TPR cannot be ordered unless notice was given, and the tribe proposes an alternate permanency plan unless there's good cause as to why the alternate plan should not be ordered. And then just to highlight the intervention piece. So tribes have the right to intervene at any point in a child custody proceeding. This includes any tribe the child is a member or is eligible for. Those tribes shall be permitted to intervene. And then the tribe may also present and participate at closed hearings, even if they have not intervened. They may also examine all reports and documents filed with the court that a decision may be based on. You can go to the next slide.
If I could just add, Austin, I think one of the open questions about this provision is it's similar to ICWA in the fact that the tribe receives the notice, of course, but it requires that the notice be provided before the legal action begins during the pending proceeding and the investigative phase. And so during our discussions, one of the open questions that I think is out there is if the tribe does not receive proper notice prior to the filing of the legal case, then what's the remedy for that? is the case dismissed because there wasn't a proper notice? Is it an error that can be fixed? There are a couple of different questions around that I think still need to be answered. And so just want to kind of flag that for folks as well. Sorry, Austin, go ahead.
Right, thanks, Therese. So now if the department attempts to enter into discussion with an Indian tribe and the tribe does not respond within the time frame provided, the department may proceed, provided that the absence of tribal response was not due, or provided that the absence does not eliminate requirements for future communication and working with the tribe, and that it doesn't affect the tribe's ability to respond to an action. So basically, the lack of response to notices does not mean that future notice is no longer required, nor does it mean that the tribe no longer can respond to an action that hasn't yet been taken. It just means that for now, that the department may proceed with the action. So this second requirement on the slide, neither a foster care nor a TPR can be held until at least 10 days after notice has been provided to the parent Indian tribe. And if once notified, the tribe or the parent may request another 20 days until the foster care hearing or the TPR hearing.
There's another provision to this, again, similar to ICWA, that allows that if the parent or tribe cannot be identified or located, then notice can be given to the secretary, who will have 15 days to notify the parent or the tribe. And so again, it's very similar to the ICWA provision on that alternate notice.
There is a provision here just defining what discussion with an Indian tribe means documented good faith efforts to actively communicate and work with the Indian tribe. And I'll pass it to Therese and Christy to sort of discuss that in more substantive detail.
Well, before we do that, Austin, and thank you. Kip, did you have anything that you wanted to add regarding notice to the tribes or Pueblos?
Sorry about that. I'm Kip Bobroff. I'm a in-house counsel for the Pueblo of Laguna. And the main point that I would emphasize is, actually I'll have two. One is we have already seen, I've already had 2 cases since the state started notifying us in accordance with IFA at the investigation stage. And already we have been able to resolve cases that I almost guarantee, if we hadn't gotten involved so quickly, we wouldn't have been able to place those children with family members. And so it's really critical. And the second thing, and this goes to parents, attorneys, and guardian ad litems, both, which is you don't have to wait to reach out to the tribe for CYFD to. And so I would encourage you to make those efforts as early in the process as possible, because that's how we get the best outcomes.
Thanks, Kip. So these are some suggestions that Christy and I have developed from a GAL youth attorney perspective. As somebody who's not a member of a Native community, I think that if you don't understand what's going on, ask. I've been working in and around the Navajo community for almost 30 years, and I still frequently talk with my colleagues who are members of the Navajo Nation to ask them if I'm missing something, if I'm confused by something, if there's something that I'm just not understanding. I've never asked a question that hasn't been responded to. And so I think that if the question's sincere and comes from a respectful place of acknowledging what you don't understand, I think it'll be respectfully responded to. By the same token, I think there's some information that, especially as non-natives or people who are not members of a community, it's not appropriate for us to know. And if somebody says, I can't really explain that to you, or that's not appropriate for you to know, I think it's important to accept that and just respect the communities within which we're working, so that so we don't misstep or cause offense. Christy, I don't know if you have anything that you'd like to add to that.
No, just always remember to reach out to the tribe. Again, there's been instances when, of course, we come into the picture when there is a petition filed. But even then, when we do get a petition, sometimes we don't know where the child is at. And so reaching out to the tribe, they tend to have the information of sometimes, they have better information than we do as far as immediate contact with family. So it's always good to get in contact with the tribe. And it goes back generally for all tribes that, these are our children, our sacred trust. And so getting the tribe involved early is key and important.
I think the other thing to consider, especially when working with ICWA social workers, is you may only have one case with them, but trust me, they have scores of cases. Most of our clients are members of the Navajo Nation. I think I was just looking at the site yesterday, and I think there are less than 10 Navajo social workers, and they're involved in cases all over the country. And so we all know that frequently CYFD social workers are overstretched and don't have enough resources. And I think it's worse for tribal social workers in the sense that they have less time and they have fewer resources. So I think it's important to try not to ask for things at the last minute. If I have a question, if I know that there's an FCM coming up, in a week or so, and I have a question about what the tribe's position is on whatever the subject of the FCM is, I try and reach out as soon as I know that there's going to be a meeting, usually a week or more in advance. I try and email them and let them know, this is my cell phone, please call me when you're available, and I will do my best to make myself available on your schedule. I know that, a lot of us have busy schedules, we're in court and things like that. I understand that they are also. So I think it's really important to not wait till the last minute to contact and work with them.
Therese, can I make two comments? One is that to reiterate that point, but also to note that one of the things that is just, I think, becoming clear is the extent to which IFPA is increasing the demands on ICWA tribal social workers, and that there is not, it's an unfunded mandate. And so the capacity of the tribes to increase the number of people is limited, particularly now. And so you have to keep that in mind. And it's not a reason not to reach out, but it is a reason to be accommodating and patient. The other thing that I would note is there are different kinds of information, and the information that, in my experience working at the Pueblo of Laguna and several other Pueblos as I like to say, a full-blooded non-Indian, is that the cultural information, traditional information is particularly closely held in the Pueblos, at least the ones I have experience with, in a way that's not the same case as my experience at Navajo. And so, and that includes for some Pueblos, things like clan relationships in a way that at Navajo it doesn't. And so to just come at this when you're dealing with the tribes from a real position of humility and one in which you don't take offense if somebody doesn't provide information or can't provide that information to you.
Thank you, Kip. I think that's an excellent point and helped clarify. From our perspective, I think from where Christy and I, when we were talking about this, when appropriate, we feel that deference to the tribe's position is important. I can't recall a time when I've differed from a tribe, from the position that a tribe was taking. But I also think that it's really important that if you have a different perspective or a different position, that that you try and talk it through with the tribal representative. Christy, did you want to add to that?
Yeah, I had shared with Therese that I actually not totally against the tribe's position, but there was a concern that came up where a child was going to be moved from one placement to the next. And my concern was regarding the child's educational needs. However, all of it could have been resolved had we all come together initially. But overall, though, I am finding that the tribe, as stated earlier, always does have their children's best interest at heart. And sometimes I'm from one tribe and my culture and norms are not always the same as others. And so being respectful and what Kip has shared is showing that humility, that we know, but we're not experts in anybody else's culture except our own. So with that, when appropriate, defer to a tribe's position.
And I would add to that don't assume that the tribe is going to take a particular position. There's a myth, I think, out there, particularly based on some of the other states' litigation, that suggests that non-Indian parents and the tribe are necessarily going to be at odds, and that's just not true. In myriad cases that I've been involved in, the tribal ICWA workers are always starting from the place of the child, what's going to be best for the child, and incorporating within that the need for the child to maintain their identity and to develop that identity in their culture. But there are lots of instances where the tribe will see the best interests as not in a direction that you might expect if you were following stereotypes. So I would just emphasize that.
So a few more things. So Therese stated this earlier, but it's important to remember that within 24 hours of initiating investigation, the department does have the duty to notify the child's tribe of the investigation, the involvement of the child, and then the department's obligation to collaborate with the tribe to identify a potential qualified expert witness, which we'll talk about in a minute, and then the obligation to identify that witness within 30 days prior to the child custody or termination proceeding. Next, over membership. So when a child is placed into custody of the department shall work with the parent, the guardian or custodian, or the tribe to establish membership at the direction of the parent or the tribe. And it's important to remember that the sole determination of whether a child is eligible or their status as a member lies within the tribe. That the tribe is the only one who can determine membership. And there is a New Mexico case here, the Marsley P case, that did find that the department has an obligation to pursue enrollment on a child's behalf. One thing I'd like to add to this too is that a child can be enrolled during a case at any point, and the ICWA would then apply. So for example, at the beginning of proceeding, a tribe could determine that a child is not enrollable. But as the proceeding goes on, and if the tribe does change its determination and enroll the child, the ICWA would then apply at that point.
So
go ahead.
I just want to, I never let an opportunity to go by to emphasize that for some tribes, membership and enrollment are the same. And that is, for example, that's my understanding of Navajo, but that's certainly not the case at Laguna. And I know there are other tribes where they're not the same thing. So Laguna, for example, has different types of membership, and some of those involve enrollment. So to be careful that you don't assume that because a child is not enrolled or even a parent is not enrolled, that they are therefore not members. That's a determination that is made by the tribe and by no one else, and it's not reviewable. And both under ICWA and under IFPA, the term in the statute is member and membership, not enrollment. So, thanks.
We also have a question. I think it's referencing, Kip, your suggestion that somebody should reach out to the tribe, even if CYFD hasn't done it. The question is, on the issue of reaching out before CYFD does, I assume there is no violation of 32A433 regarding confidentiality if the GAL, for example, reaches out to the tribe if the tribe is not listed in that section. That is, a GAL would not need a court order to be able to do that, I assume. The way I understood your comment, Kip, was that the case, once the case is started and a GAL or youth attorney has been appointed, that person does not necessarily need to wait for CYFD to notice the tribe, that we could reach out to the tribe on our own. Was that what you were referring to?
Well, yes. And I assume that as soon as a GAL is appointed, that means the case has started. And frankly, I hadn't thought of what 32A-4-33 might mean for that. But it's, as Therese has said, there are a number of things that haven't been fully worked out yet. And this may be one of them. I can't imagine that a New Mexico court would hold it against a GAL if once they had been appointed to be the attorney for an Indian child or a child believed to be an Indian child and the GAL reached out to the tribe, that any New Mexico court would object. But I hadn't thought of that, so I appreciate that, Jim, for raising that.
Jim, did you want to add a comment to that, or does that?
No, I think Kip's response was, I mean, I've, had a case involving the Pueblo of Nambe. And my thought, if I ever had another one of those cases come up, that my first thought would be, much sooner than I did in the previous case, would be just to say, hey, there's this child here. Don't know if you all have gotten any notice about it, but I'm the guardian ad litem, and let me help in any way that I can to set up the communication and make things going. So that's all I had in mind. But every once in a while you do something that seems obvious and somebody else is not as it doesn't think it's as obvious as I do. So, but thank you for the response.
Good point.
And I think that's the ideal approach.
Sorry, Therese, can you go back to membership? There's just one more point I wanted to make. In section 16D of the IFPA, there's one issue that sometimes come up. So if a child is eligible for enrollment in multiple tribes, and if there's a dispute as to which tribe is the Indian child's tribe, the court determines that the tribe that the child has more significant contacts, and there's a list of considerations in section 16D, but it's the tribe in which the Indian child has more significant contacts is considered the child's tribe. However, remember that if a child is eligible for membership in more than one tribe, all tribes that the child is eligible for has a right to participate as an intervener. I don't know if you guys have seen that come up in your guys' practice with multiple tribes having an interest. But we can go to the next slide here on jurisdiction. So the way jurisdiction works in IFPA cases, if the Indian child resides or is domiciled within the exterior boundaries of the reservation, then the child's tribe has exclusive jurisdiction, except when jurisdiction is otherwise vested in the state by law. Or if the child does not reside or is domiciled within the exterior boundaries, if the child remains still under the jurisdiction of the tribal court, then the tribe does retain exclusive jurisdiction. And if the child does not reside or is domiciled within the exterior boundaries, then upon a motion for transfer at any stage of the proceeding, the department shall ask the tribe in writing whether the child's tribe will accept jurisdiction. If the child's tribe does not accept jurisdiction, then the state court retains jurisdiction. However, again, the tribe, parent, guardian, and custodian do reserve the right to petition for transfer. And then on the other side of that, if the tribe does accept jurisdiction, the court shall transfer unless either parent objects or there's good cause that exists for transfer. Okay, I will pass it over to Christy on this one.
All right. Myself and Kip, regarding tribal state agreements, there is a law out there, but also within IFPA that the department is required to make good faith efforts to enter into an agreement with individual tribes and pueblos to coordinate the care and custody of Indian children. And that's going to be in the section 28.8a. A state tribal agreement may include an agreement regarding whether a case needs to be filed and whether the case would be filed by the department in court or by the appropriate tribal agency in tribal court. Agreements may also include exclusive jurisdiction over cases filed by the department in which the court and tribal court would otherwise have concurrent jurisdiction, and the process to transfer cases between a court and a tribal court. And lastly, there may be an agreement regarding procedures for the assessment, removal, placement, and custody of Indian children. Here, I would like to hear from Kip from the Pueblo of Laguna on just his insights into state tribal agreements. If Kip is still on the line.
Sorry. My primary
insight would not be that insightful, if you will, other than to say that having negotiated 3 or 4 state tribal agreements with 3 or 4 different departments, it's not for the faint of heart. And I think this is another one where resources matter. So we've been able to get 3 done in 3 years, and we have a 4th, not with CYFD, but that's because Laguna has in-house counsel, and it just isn't easy either from the state side or the tribe side, getting all the appropriate decision makers on board. So I hope that CYFD will work with the tribes to develop some models with some policy choices that tribes can make. And then, of course, tribes will propose their own. But again, I think this is going to take more work to implement IFPA.
Thank you, Kip. And just to add, any formal agreements, anything that affects Indian kids or Indian tribe, there is the State Tribal Collaboration Act that does require for the state and tribes to have that formal, meaningful discussion. And really, I like to just think of it with the acronym of CARE, have that cultural awareness, be respectful, and be engaging with the tribe, especially when it comes to their members or those eligible for membership. With that, I will pass it on. Oh, it's still under state. Sorry about that.
But we're actually running short on time, so I think we should maybe move forward unless you have something else you want to specifically add, Christy.
Not necessarily, so we can move on.
Okay, so moving to the qualified expert witness. So these provisions are pretty similar to the ones that were in ICWA or are in ICWA. So the court shall not order a foster care placement of an Indian child at adjudication unless there's clear and convincing evidence that is presented that includes the testimony of 1 or more qualified expert witnesses, demonstrating that the child's continued custody by the child's parent, guardian, or custodian is likely to result in serious emotional or physical damage to the child. And the cases of termination of parental rights, unless evidence beyond a reasonable doubt is presented, which includes the testimony of 1 or more qualified expert witnesses that demonstrates the child's continued custody by the parent, guardian, or custodian is likely to result in serious emotional or physical damage to the child. So the role of the QEW is to testify on whether the continued custody is likely to result in serious emotional or physical damage to the child. As I said earlier, the burden of proof is clear and convincing evidence in foster care, and then beyond a reasonable doubt in termination of parental rights. And then QEWs are important to ensure that the norms, culture, and traditions of the tribe are not used as premises for removal.
So at the risk of shortchanging our conversation on the qualified expert witness, we did have a question regarding the exclusive jurisdiction. It's where the child was domiciled within the exterior boundaries of the tribe when the case was commenced. Can the district court retain jurisdiction over a case even if the tribe declines to take the case, or will the state court be compelled to dismiss? Anybody want to weigh in on that?
Well, I would certainly make the argument that the state court is compelled to dismiss because I don't think it has jurisdiction. Exclusive is exclusive, it seems to me. And ICWA is pretty explicit as providing for the difference. So I don't think the state court would have jurisdiction. at that point.
I would tend to agree with that. And then where would they go? I mean, they don't have any ability, they don't have jurisdiction to make any placement decisions or anything like that. I think I agree with you, Kip. I think exclusive is exclusive. I don't know, Christy, Austin, do you have any thoughts on that, or shall we go back to QEW? I hope that's helpful, Michael.
And I sent out all these letters with the benefit search, but
Nailed it on the head.
Okay.
All right, the next one we have as far as QEW is the latest Court of Appeals opinion that came out was Douglas B. And what I've seen with this in regard to Douglas B was it now appears that there might be a need for 2 expert witnesses, one to address the social and cultural standards of an Indian child's tribe, and the second for the to speak on the serious damage that might occur. However, in discussing this with Therese and other colleagues, laying the foundation for the QEW, that one that they can, if they're a QEW from the tribe and they can speak to both the cultural and the serious damage, laying the foundation is crucial and critical. And of course, this still involves the expert rule 702, that the expert does have to have that knowledge, skill, training, and education. I don't know if Therese or Kip, you want to add anything to that?
No, I think, and as Nancy just added in the chat, this case is before the Supreme Court and the arguments on July 11th. So I think it'll be an interesting case to watch.
Right.
If I could, this is Nancy, if I could say, I don't think you necessarily, even if the Supreme Court affirms Court of Appeals, which I think they should, since I represent Dad. But I think you don't necessarily need 2 experts, but it would be a somewhat rare expert that I think you'd have to have somebody who's familiar with the cultural traditions of the tribe. So very familiar with the tribal issues to be able to testify on that issue, and then also somebody with a mental health background. But you could certainly have somebody that had both. A very high-level social worker who grew up on the child's tribe with the, as a member of the child's tribe, or somebody like that could. It's just going to be harder to find someone, I think.
Thank you for that. The next one is part of the requirement of a QEW. The court shall receive testimony from 1 or more QEWs in all adjudicatory hearings pursuant to the, of course, to the Abuse and Neglect Act. Here, the court shall receive testimony from a qualified expert witness, regardless of whether the parties to the proceedings have stipulated to a finding of abuse or neglect. This, again, if being new, one of the things that we did discuss, it does present a question, and Therese chime into this new language that's highlighted in bold. A QEW Teresa, chime in.
Yeah.
I'm sorry.
Sorry. No, I think these were more my questions, so I apologize, Chrissy. I just didn't want to interrupt you. So I think this last sentence that's in bold type has some interesting ramifications. So for instance, if Douglas B is upheld, do you still need the 2 experts? Or do you just need the one to affirm, because you already have a stipulation. So if you have a stipulation that, the children should remain in custody, the parents are either not contesting at an adjudicatory hearing to, a lower allegation of neglect over abuse, do you still need a qualified expert witness to testify to the causation, the causal relationship? Or do you just need somebody to testify that the placement and the proceeding is not contrary to the cultural, I'm sorry, I'm phrasing this improperly. It's not a violation of the cultural norms, because that was the purpose of ICWA and IFPA, right? To make sure that children weren't brought into custody because of cultural standards or traditional standards. And so I think it presents an interesting question about that qualified expert witness, about even though you have a stipulation, do you still need to cover those two things? The other thing I find interesting about this is it's very specific about adjudicatory hearings and termination of parental rights, which is completely fine. I don't have any problem with that, obviously. But what is happening more and more up here in the 11th anyway is children are being placed with through permanent guardianships, not TPRs. And I think that's happening also down in the ICWA court, if I'm right, Christy. So if the department is moving more and more to permanent guardianships rather than TPR, because it's more culturally appropriate for many Native communities, then you don't need a QEW for that. So you're achieving the same sort of permanency, but there's just a different standard. And I think it's the result just of drafting. Like when this statute was drafted, it was before Douglas B, and so there wasn't a consideration of it. But I just think it presents some interesting questions. So I drive around a lot, so I get a chance to think about these things. So I don't know if anybody has anything to add to that. Sorry, we only have about 10 minutes left, so I just want to be respectful of everybody's time too.
As you were asking that question, I was thinking that could be a question for Nancy on the 11th. But I think that we could have a really interesting discussion about it. Given that you just told us to hurry up, I do want to get to emphasize that GALs and respondents' attorneys may need to exercise a little encouragement on behalf of the department to make sure that they get GALs and get started on finding them quickly, because not having a GAL, I said GAL, I meant QEW. Not having a QEW when you need one can really slow down and mess up a case. And potentially if they go forward, it can just create all kinds of problems. So make sure that happens. Some tribes like Laguna, we frequently will provide the QEW, but other tribes won't do that. So it's worth making sure that the state is meeting its responsibility.
So Nancy's put in the text, in context of Douglas B, you'd still need an expert to testify that staying with family would cause serious emotional harm. It's a separate issue from whether a child is neglected or abused. I agree, Nancy. I think that's what this provision means. But I would go one step further. I think you still need potentially two experts. I think you need to address the causal relationship and the traditional and cultural norms.
Yes, I think you need two. I think that's absolutely right. And I think you can even read that into the Court of Appeals decision, and then we'll see what the Supreme Court says. But yes, I think if the Court of Appeals opinion stands, you would likely need two experts. You definitely need two areas of expertise. What I'm saying is you could have a person that was qualified to do both.
No, I agree with you on that. I'm not disagreeing with you that you could have one person, but I agree with you that that's potentially problematic. What I'm saying is under this provision, even if you have a stipulation, I think the department still needs to call experts that can either one or two experts that can address those two things.
Absolutely. In fact, in Doug B, I think that's absolutely true. In Doug B, they proved the case on the merits. That there was abuse, I think. It might have been neglect. There was exposure to domestic violence, that type of thing. They proved that piece. And the argument on appeal was they still had to prove that staying with a neglectful parent pursuant to ICWA would cause serious emotional harm. So I think we're saying the same thing.
I think we're
No
saying
matter
the same
what,
thing
you
as
have to
well.
prove it. You have to prove that element no matter what has happened in terms of abuse or neglect.
No, I think we're saying the same thing. I think what I'm trying to emphasize is even with a stipulation. So I
Right.
think this
No,
is
that's
going
true.
to, I think this changes our practice.
It
So-
does. Yeah, no, a big time changes practice. I think you're absolutely right.
Hello, this is Marcella King. Can you hear me?
Yes.
Yes, I just wanted to say that in the McKinney County, we usually have the social services worker from the Navajo Nation Division of Social Services come in, and it will be just one expert witness. They're considered the expert witness, and generally they're Navajo individuals, so they'll talk about the traditional cultural practices, the language, and so forth, and they'll be considered the expert. So I'm wondering, when you say that we should have two experts, but what I'm reading here says one or two experts. In our case, we can still just have that one expert testify to both the causal and also the cultural impacts and then or necessities. Am I correct on that?
I believe so, but in regards to Ms. Simon's question or adage was if there's issues with mental health or issues of that sort, another expert might need to be called in.
There has to be somebody who addresses the causal relationship around the harm. And as I recall correctly, and Nancy will correct me, I'm sure, since she's intimately familiar with the case and the decision, is that the Court of Appeals specifically said it had to be, and I don't mean this with any disparagement, but I think the language was it had to be somebody with more than just a standard social work background.
Yes. I think what Ms. King is describing, that expert would fit the bill. You'd have to lay the foundation, but somebody that's
Right.
a high-level social worker, like lots and lots of experience, could say that she had some kind of mental health background, and I'm a member of the Navajo tribe, so you can treat me as an expert in Navajo cultural traditions because of my experience and all that. That person could testify as to both. But not every tribe will have somebody like that on call, I would guess, just based on the work I've done in district court. But so you just need to be prepared to figure out whether the person that's being called has both expertise.
Right, and I think it goes back to the the expert rule of looking at skills, knowledge, and experience, as
Right.
well as education and training.
Right.
And so I think, and that's kind of what Christy was referencing earlier about really carefully laying that foundation. And what I've seen in the past, at least in the 11th, and Chester, please correct me if you think I'm stating it too simply, is people will talk, because we also, Marcella, have a lot of the ICWA social workers from the Navajo Nation who are excellent, but there's not that delving into that. It's just like, I'm a social worker. This is my background as far as the cultural norms, but I think there's going to have to be that foundation is going to have to be laid much more carefully in the future.
Okay, so Teresa, if you have any questions for these social workers, qualified experts, can you please send me that information? Because that's the problem that I have sometimes when I personally believe that they shouldn't qualify as an expert, and they think they're an expert just because they're Navajo and they know the cultural practice, they know the language, and they grew up on the reservation. And that's what you probably hear. And sometimes I just feel like there should be more to than just that.
Well, and one thing about IFPA is that it requires the state to ask the tribe, in this case Navajo, who do you want to be your expert? And so that provides, it's part of the effort in IFPA to shift power to make those decisions to the tribe. We tried to get it in there that the tribe would have a veto, but the department rejected that.
Sorry, I was trying to kind of expedite to that part, Kip. So, yeah, so the department has to request this in writing. And then the tribe has an opportunity to designate the qualified expert witness. That's what you were referencing, right? Kip? Okay. Austin, did you have anything else that you wanted to say about this piece?
I think you guys went over a lot of it in that discussion. On slide 18, we have a slide here that talks about the qualifications, which a lot of them were just mentioned. But one important piece is that in the IFPA, the QEW cannot be an employee of the department, is something that the IFPA adds.
And will be a difference between New Mexico and Arizona, because at least our experience in Arizona seems to be that that's their practice.
Is the QEW is an employee of the department?
From a separate division of the department.
Huh.
Right.
At least
So the
that's
ICWA,
been my experience.
I think the ICWA only requires that the QW cannot be the social worker on this specific case.
Right.
Yeah.
But it can be as Kip said, a worker from a different division. But that's what the IFPA does, is no longer an employee of the department. And then, yeah, I think you guys covered everything else.
And then this final provision, and we're right at time, this final provision just specifies that the state and the tribes will work together to develop a list of qualified expert witnesses. And so that's another thing that the state has both promised and is obligated to work with the tribes on. And we're right at 1 o'clock. Sorry, I didn't think we were going to make it. Does anybody else have any comments or questions or anything? Okay, well, thank you all for making time to be here. I really do appreciate your interest in this. As I said, most of these sections go into effect tomorrow. The one section that doesn't go into effect is a training section, so it gives another year for people to get together to provide training. And also, as I mentioned, Twyla is going to be working with some other organizations to provide more in-depth information and training on working with tribes and Pueblos. I really appreciate, Kip, you taking the time to join us. Your perspective is really important, and we want to make sure that that's heard, because of the importance of, the whole emphasis on a statute is strengthening the role of the tribes and the Pueblos in this process. So I hope you all have a great day. Thanks again for taking the time to be here.
Thank you, everyone.
Thank you, Christy.
Good to see you, Marcella.